All right. Hello, everybody. My name is Timothy Scott, or TJ Scott. I'm a Minnesota estate planning attorney and the owner of the law office of Timothy J. Scott. And I'm so happy to have so many people joining us here this evening. We're going to be talking today about something that I know is a difficult topic. The fact of the matter is that we are all going to die someday. It's a heavy way to start a presentation that you chose to be at 7 p.m. on a Wednesday evening, but it's a fact of life, and it's a fact that we all know, and that's why we want to get this information and learn this information. I really believe that knowledge is power, and today I want to empower you, I want to educate you, and I want to give you some peace of mind about how you can get your affairs in order and how you can deal with this difficult topic in a way that really takes care of your family in the best way possible. So today I have some valuable information that I want to share with you and some valuable offers that I will be sharing at the end of the presentation. But first, let's start here. The best way to learn today is to be present with me here. If you have other windows open, if you have other tabs open right now, I encourage you to go ahead and turn off those distractions and give yourself this time that you've already set aside. I always say your future self is going to be glad that you took the time to be present with me and learn with me this evening. This is complicated stuff. It can be. But I promise you, I'm going to walk through it. I'm going to make it as simple as possible. I'm really, I believe very strongly that everybody has a right to know this information and that we should make it as simple as possible so that people can understand it in a way that's accessible to everyone. All right, let's dive in. As a bonus, if you stay until the end here today, I'm going to tell you how you can get a free one-on-one meeting with me to talk about the things that you have and the people that you love and how you can protect them. Plus, I'm going to give you a bonus gift that makes it even easier to get a personalized and tailored estate plan in place for the people that you love. Let me start with a poll. So you should see this pop up in just a second. The first poll that I want to get a feel for the audience is, do you have an estate plan? And what's listed here, a lot of times when people hear estate plan, they think will, or they think, incapacity, they think healthcare directive or power of attorney. Most people think will, but the truth is that an estate plan isn't one specific document. An estate plan is a larger, all-encompassing thing. Oftentimes it includes a trust, sometimes it includes a will. If you have minor kids, it needs to include guardianship nominations. Who's going to take care of the kids if you can't take care of them? It should include incapacity planning, a healthcare directive, a power of attorney, and it also should reach beneficiary designations on the assets that you have that can pass by beneficiary designation. So these are some of the elements of an estate plan, and we'll talk about a few more here tonight as we get going. And I'm seeing here that that the vast majority of people are saying no, they do not have an estate plan in place, and it's not too surprising. In fact, let's see here. Something like 69% of people in America do not have an estate plan in place. And there can be lots of reasons that you might not have an estate plan in place. I'm going to launch another poll here and let me know if something here resonates with you. Maybe you feel like you're too busy and you just haven't gotten around to it. And let me tell you, I completely get it. Life today is really busy, but again, if that's the case for you, I want to commend you for being here, taking some time and educating yourself on this topic. I have 4 kids. I run my own business. I'm a lawyer. I am very busy. I completely understand what it's like to be too busy. But again, you're here tonight. You're taking the first step. Well done. Maybe you feel like you're too young. Honestly, anyone over the age of 18 should have some estate planning documents in place. Maybe they don't need the full bells and whistles of an estate plan that includes all-encompassing things. But I can tell you, I've helped young families, and in particular, I think of one young family where a young father had passed away and unfortunately left something of a mess for his wife and minor daughters. But it doesn't have to be that way. I've helped young people in other cases, and I've seen the relief and I've seen the weight, the burden off of their shoulders, and how happy they've been afterwards. A lot of people think that estate planning is too expensive, and I see that some people are saying, yeah, I think estate planning is too expensive. Before the existence of word processing, maybe, but today estate planning is really for everybody. In fact, I'm going to offer some bonuses at the end that make it even more affordable to get a great estate plan in place for the people that you love. And maybe you're worried about jinxing yourself. And I see nobody is fessing up to being worried about jinxing themselves, but I hear this all the time as I work with people. I can tell you though, I've done dozens of estate plans, and luckily I've never seen any kind of correlation or causation between getting an estate plan done and having something happen in their lives. It's kind of a TV trope, right? That the police officer on the last day on the force, that's when something bad has to happen. But again, I can tell you from my experience, I haven't seen that correlation. And I always say, I think that my clients tend to live more intentionally and get more out of their life, have a burden removed from their shoulders, and it really benefits their life to get this done. All right, I am going to share another poll. It's poll after poll after poll. Sorry about that, but I really like to know where everybody is coming from. And so this poll is, if you have a plan in place, great. What are you hoping to learn here tonight? And even if you don't have a plan in place, I hope that you'll share with me, what is it that you're hoping to learn here tonight? Maybe you want to know if an online or do-it-yourself will is okay and is going to take care of your family in the way that you think that they should be taken care of. Maybe you did a plan, but it was 20, 30 years ago, and you're not sure if it's up to date. You're not sure if there's any updating that needs to happen. We'll talk about that today. And maybe you just want to have a better understanding of estate planning. Maybe you want to have a better understanding of some estate planning that you've done in the past. Maybe the attorney didn't really explain it to you, didn't inform you and educate you as they were going through the process of writing your estate. And now you want to have more information about it. And if you have any specific questions that you want to bring to my attention or any specific reasons for you being here tonight, I encourage you to post that in the chat. And I will watch that. I will watch and see if anybody posts in the chat and be sure to address those questions. So I'm seeing some people want to know if an online will is okay. I'm seeing some people who want to have a better understanding of their plan or estate planning in general. And I know from my conversations with some of you that there's a thirst for knowledge, that a lot of people really want to have more knowledge about this topic and get more information on it. So I appreciate everybody who was willing to share there about why they're here and what they want to learn. All right. Now, I just want to take a moment here to say, whether you have an estate plan in place, whether you don't have an estate plan in place, whether you're just here looking for information, whatever the case is, whatever is bringing you here, if you have concerns about cost, if you have concerns about, how much time this is going to take and how simple I can make it for you, you're in the right place. You're in the right place if you have someone or something that you care about and that you want to protect. And you're in the right place if you've done an online or do-it-yourself will, but you're not sure if it's going to work for your family after you're gone. And again, you're in the right place if you're nervous about how much this is going to cost. Again, I have 4 kids. It's kind of crazy to think about that sometimes, but I'm cost sensitive, absolutely, because raising 4 kids is not inexpensive. And I'm going to talk about the cost of estate planning. I'm going to talk about the cost of not having an estate plan done, as well as what you should expect to spend in order to get a well-drafted, tailored estate plan done for you that's going to take care of your family. But the reality is, estate planning isn't about you. It's about the people that you love. And this is something that really rang true for my wife and I recently when we were updating our estate plan, that the estate planning that we were doing wasn't like starting a business. It wasn't like making an investment in some sort of stock or CD or something like that. It's not going to enrich us. It's not going to bring us wealth in the here and now. But we were doing it for our kids to make sure that they were well cared for if anything should happen to us. And the truth is that your loved ones are going to know whether you lived up to your promise to take care of it after you're gone. And you want to leave them the gift of a well-drafted estate plan, of having your affairs in order and making sure that they are well cared for. It's a lovely gift to leave the people that you love. So here are the kinds of things that we're going to talk about today. And here I have the final question that I'm going to ask I know we're probably a little sick of the polls at this point, but please, if you would take a look at the poll that I just popped up and let me know what kind of demographic situation you're joining me from. It's going to inform how I talk about things in a little bit and how much emphasis I put on things. So please do share with me where you're coming from. Here are the things that we're going to talk about today. We're going to talk about planning for incapacity, and that means who can make healthcare decisions for me, who can make financial decisions for me if I become incapacitated, meaning in a coma or having dementia, something like that, where I can't make decisions on my own anymore. And we're going to talk about planning for when you pass away, and that might mean guardianship if you have minor kids. And I do see a number of people here who have minor kids, so I'll take a little bit of time to talk about that today. But other topics apply to everybody. We'll talk about probate, and we'll talk about what that means for your assets and for your estate. We'll talk about the time, cost, and public nature of the probate court process, and also how it can be avoided if that's something that you want to do. We'll talk about estate taxes, and there I get to give everybody some good news about estate taxes, or almost everybody some good news. We'll talk about unclaimed property and how property becomes unclaimed and ends up in the State Department of Unclaimed Property. And we'll also talk about intangible assets, things like your stories and your values, and how you can share those with the people that you love. But before we jump into all those topics, I want to share just a little bit more about me so that you know who's talking to you tonight and have a little bit better picture of who I am. Thank you for sharing in that poll. I am going to go ahead and share the results here for just a second so everybody can kind of see where people are coming from as I talk a little bit about myself. So this is my family. And again, we live in Bloomington, Minnesota. My wife's name is Tobin, and my kids are Ben, Elizabeth, Margaret, and our newest is Bridget. And Bridget is only 3 months old. Ben is 10, Elizabeth is 7, and Margaret is 5. And I can tell you, my family is my whole world. I spend a ton of time with them, and I love them. I graduated from the University of St. Thomas School of Law near the top of my class in 2012. And the very next day, my son, Ben, was born. I found a job after law school with a small estate planning and tax preparation law firm in Minneapolis, and I love the clients that I was able to work with. At the same time, I didn't always feel like I was providing the value that my clients deserved. And so after a little more than 3 years, I ended up leaving the law firm. This is actually a picture from my last day there. Audio quality is too low to understand, very choppy. If there's a replay, please send a link. I'm getting less than every other syllable. I am so sorry to hear that. If anybody is experiencing the same, would you please share that fact in the chat that you're struggling with the quality of the audio or with the quality of the recording or the video here today. Hopefully, I'm coming through okay for other people. I see somebody saying you sound perfect, no issues. I can hear you. Good. I'm glad to hear that. And I'm sorry that that you are having some audio difficulty, or that the webinar is having some audio difficulty in reaching you here. Someone has to graduate at the bottom of the class. Now, this was not said about me. This was something that has stayed with me from my parents' very negative experience working with an estate planning attorney who helped my grandmother. And I remember them saying this in particular: someone has to graduate at the bottom of the class. And there was a big reason for this negative response to that attorney. I don't actually think it was that attorney's knowledge or intelligence or anything like that. I think that it was the model that this attorney was practicing under. And I'll talk more about that faulty model. I call it planning for death later. But first, I want to talk about some of the aspects of estate planning and really inform you and educate you on some of these things. And I see somebody else is saying video and audio are great. That's fantastic. I really appreciate that. Thank you. So again, I know not everybody has minor kids here, but there are enough people with minor kids that I want to share a little bit of information for them. If you have minor kids, it is vital that you have guardianship documents in place. And guardianship means a couple of different things. The first type of guardianship that I'm going to talk about is short-term guardianship. And the way to think about this is what happens if you leave the kids with a babysitter or you leave them with some trusted family member and you go out for a date night, and for whatever reason, you don't come home. And if there's no plan in place, what's going to happen? Well, eventually that babysitter is going to call the police and get the police involved. And the police coming to the house and seeing that the kids are staying with this babysitter are going to have to evaluate what to do with the kids. Likely what that means is that Child Protective Services is going to be called, and Child Protective Services is going to have to take custody of the kids until some judge can decide who the kids should be staying with. And I'm not saying this to, ride Child Protective Services or anything like that. I think that they do the best that they can with what they're given. But I can tell you, I don't want my kids to have to spend any time with Child Protective Services if I can avoid it. And so it is very important to plan for short-term guardianship and to have legal documents and a plan in place so that there's somebody who can take custody of your kids if something happens and you don't come home, and you're able to make sure that they're cared for by someone that you choose, as opposed to having them spend time with Child Protective Services. Long-term guardianship, on the other hand, is who's going to raise those kids until the age of 18. And we know our kids best, right? As parents, we know our kids and we know where those kids flourish and where they would struggle. And if you don't have a plan in place, if you don't have long-term guardians listed, then unfortunately there is a plan, and the plan is that a judge is going to decide who is the best person to raise those kids. And I always say, if that means that Uncle Larry is the best person under the judge's discretion to raise the kids, even if you wouldn't want the kids to spend 15 minutes with Uncle Larry because of what he is or what he does or whatever the case might be, if the judge decides that Uncle Larry gets your kids, then Uncle Larry is going to get your kids. And unfortunately, it really is. It's a plan that you're probably not going to like, because it's not going to match who you think that your kids would flourish with. And again, this is why it's so important to make sure, if you have minor kids, that you have not just the short-term guardianship taken care of, but that long-term guardianship taken care of. All right, so the rest of this is going to apply to everybody, and we're going to talk about how are the people that you love going to receive the assets if something happens to you. So if you currently don't have an estate plan in place, meaning if you don't have a will in place, you don't have a trust in place, you haven't, maybe you've looked at your beneficiary designations, or you did them when you first started working with your job or whatever it is, but you haven't looked at the beneficiary designations in a long time. Whatever the case, if you don't have a plan in place, there is a plan that the state has put in place for you. And unfortunately, if the only planning that you've done is with a will, then this plan for you is the same plan. That the plan for your estate is a process, a court process called probate. Let me take a step back and talk about, if you don't have a will in place, the state thinks they know who should receive your property. And what the state thinks should happen with your property is that first, a lineal descendant should receive. So that means children, grandchildren, great-grandchildren, great-great-grandchildren. The state looks for somebody who is lineally descended from you, easy for me to say, lineally descended from you, in order to receive your property. If that's not the case for you, if that's not the ideal to have a child or a grandchild receive, or if your children or grandchildren shouldn't all receive from you, then you really need to get an estate plan in place. And even a will would be better than not having anything in place at all. If the state isn't able to find any lineal descendants for you, then it will go up to your parents' level, out to brothers and sisters, nieces and nephews, grandnieces and nephews. It'll look for somebody who's lineally descended from your parents. If it doesn't find anyone there, it'll go up to your grandparents' level and look for somebody who's lineally descended. That's the intestate statutes. That's what happens if you don't have anything in place and you die. Those are the people who get your assets. If you have a will in place, you can decide who receives your assets. But having a will in place still does not avoid this court process called probate. And the court process called probate is, first of all, expensive. The process costs something like 3 to 6% of the gross value of the estate. There are a ton of fees that weigh into this: attorney's fees and executor's fees, appraisal fees, bond premiums, filing fees, creditors. There are all these fees that are involved in the probate process. And I can tell you, I have seen probate processes cost more than six figures before. In fact, Prince's estate, Prince's probate, has cost more than seven figures. Maybe it's even gotten up to eight figures at this point. With all of the attorneys fighting and all of the different parties involved, it can be an absolute mess. But even if you have a simple estate, it's expensive. You can expect at least 3 to 6% of the gross value of your estate to go towards paying costs of the probate process. Also, probate is slow. In Minnesota, it takes a minimum of 6 to 12 months to get through the probate process. Oftentimes, it even takes something like 12 to 18 months. The truth is, we'd like it to go faster, but it just can't. It wasn't designed that way. It's a slow administrative court process where your creditors have time to come forward and make their claims known. And so there are a lot of delays that are just built in. And I have down here, probate is a lawsuit that you file against yourself with your own money for the benefit of your creditors. It's just as bad as it sounds. It's not ideal. Probate is also public, and I'm showing you here the last will and testament of Anna Nicole Smith. And she's been gone for a while, but wills are totally public, and having a will doesn't avoid probate. In fact, it assures probate. And that probate case, the court case, they want to be as open and transparent as possible. And that means that they're going to make your will public. That means that they're going to make an inventory of your assets public. That means they're going to make a plan of distribution and who's receiving your assets after you're gone. All of that is going to be public information that anyone can go to the courthouse and access. So unfortunately, we all know that this world isn't an ideal place. And there are predators out there who can find this information and be put on notice that your loved ones are going to be receiving money and take advantage of that fact. If you have minor kids and you don't have a plan in place, then unfortunately, those kids could take outright without any restriction at the age of 18. And I think we all know stories about kids who've received assets at way too young of an age. And it's really disturbed their ability to deal with finances and to deal with numbers. And it's also, it can distract people from getting an education and starting on a career that they enjoy and that they will thrive at. All right, well, here's a chance to actually calculate your probate estate. And what I have here is an example of some assets that might be in a typical estate or a typical probate. So I have the family home listed. I have a rental property listed. Look at those real estate prices that could probably use a little finagling, although who knows what's going to happen here in the next year. Maybe those will be more accurate then. I also have furniture and household goods listed. I have some automobiles listed, stock, bonds, and bank accounts, and then a business interest as well. And you can see here, the gross value of this estate is about 850,000. In fact, it's not about 850,000 because it's a nice even number because I created those numbers. So 850,000, well, you can calculate what 5% of the gross value or what 5% of that gross number is. And the way that you do it is you just move the comma over one place and then you divide that number in half. And so here I had estimated probate costs and fees of $42,500. Probate is expensive and nobody wants to spend $42,500 or nobody wants their estate to be depleted by $42,500 just because of the planning that they did or didn't do. To add a little wrinkle, if you have certain assets that are payable to minors, so maybe you have a plan that you're going to put beneficiary designations on everything and it's going to take care of everything. Well, if those assets are payable to minors, either your children or grandchildren or great-grandchildren, whatever the case might be, then those assets that are payable to minors, including things like life insurance and retirement accounts, have to go through another process. They have to go through a process called conservatorship, which is very similar to probate. In fact, they have to go through probate first and then conservatorship. and that adds to the expense of the probate process. And so here you can see if you have a life insurance policy and some retirement accounts, all of a sudden those costs of probate really balloon and really get out of control very quickly. But I have great news here. There is a foolproof way to avoid probate. And the foolproof way of avoiding probate is by fully funding something called a living trust. What is a living trust? A living trust is an agreement between two people. Obviously, the preference is for it to be written down, but the truth is you can create a trust just by having two people make an oral agreement with each other. But really, to have a living trust that's going to survive after you're gone, you need to write it down into a trust agreement. And that's a document that an attorney can draft for you and can really guide you through and empower you to make decisions in that trust agreement. But what a trust agreement does is it takes property from one person called the settlor. This is the person who starts with the property, and the settlor gives that property over to a trustee. And the settlor writes down exactly what they want the trustee to do with that property. And the trustee says, yes, I agree. I'm holding this property for you, settlor. And so I'm going to follow the rules that you laid out in your trust agreement. And I'm going to do with this property exactly what you've told me to do. So what that means for funding your trust, it means making sure that you take the assets that you have and give them over to the trustee so that the trustee has possession of them and can follow the trust agreement. For a living trust or a revocable trust, you are in both roles. You're the settlor who starts with the property. You're also the person who has control over the asset. Okay, you're the trustee. That's the person with the control over the asset who's following the rules that have been laid out in the living trust. And because you're in both of these roles, the person who gets to write the rules and the person who's following the rules, it means that you can use those assets for whatever you want. You also happen to be the beneficiary. So you can use them to benefit you in any way that you want. You can use those assets to go and buy groceries. You can use those assets to go and buy a Tesla. Whatever you want, they remain your assets and you have complete control over them. The reason it's also called a revocable trust as well as a living trust is because you can revoke or amend that trust at any time. Again, you're serving in both roles. You have two hats on, the hat of settlor, the person, or grantor, the person who created the trust, and the role of trustee, the person who has taken property and agreed to follow the rules that the settlor has laid out. So fully funding a living trust means different things for the different types of assets. Things that are titled property, things that where the government keeps track of who owns the property. And one of the best examples of this is real property. Is your home or is a vacation property, something like that. The way to transfer that type of property into the trust is by executing a deed to put that property into the trust. Other assets like investment accounts and bank accounts, you need to communicate with your bank and communicate with your investment, the person who's holding your investments, and find out the way to title that account, to put that account into the name of your trust so that your trust is now holding it. Oftentimes at the bank, it just means taking a trip to the bank and signing new signature cards. With an investment account, it often means submitting a form that's been notarized or stamped with a medallion. So those are the ways that you're able to put those assets, again, taking them from your name as settlor and putting them in the name of the trustee in that name of the trust so that the trustee can exercise control over them. The stock and bond certificates, you need to actually transfer those stock and bond certificates into the trust, and you can do that oftentimes in the back of those and by sending them in. Personal property is assigned into the trust using either an assignment of personal property or a bill of sale. And then life insurance and retirement accounts, we don't want to change the title on those, or we don't want to change the name on those. Oftentimes that's really difficult to do, but we can put those into the trust with beneficiary designations after you've passed away. I haven't seen any questions, so please, if anybody has any questions, I encourage you to find the chat box or find the Q&A button and ask those questions. But if there aren't any questions, then I'm just going to keep pushing forward here. All right, now let's talk about estate taxes. Estate taxes, again, is a place where I get to give almost everybody very good news. And the reason for that is on the federal level and on the Minnesota level, even though we have estate taxes on both, there are exemptions from the estate tax for the first certain amount of money. So on the federal level, there's an exemption amount of over $12 million. And even better, you get to double that number if you're married. So if you have more than $12 million, or if you have more than $24 million if you're married, then I would really recommend that that you do some estate tax planning, but that's only includes very, very few people. And so that applies to almost nobody. I see somebody asking a question here, and I'll get to that in just a second. In Minnesota, we also have an estate tax, and we also have an estate tax exemption. And the estate tax exemption in Minnesota is $3 million. So again, the estate tax in Minnesota, which can have a rate of up to 16%, still doesn't apply to most people. Most people don't have an estate that's worth more than $3 million. And so again, I get to give a little bit of good news. All right, so I have some questions here and I'm going to answer them live. Would you recommend a living trust for someone who has less than $40,000? The answer to that question is, there's a lawyerly answer, it depends, but in general, no, I would not recommend that somebody who has less than $45,000 gets a trust. But that really depends on a couple of different things. Number one, if that person owns real estate, even if they don't have equity that's more than $40,000, just having real estate alone means that their estate is going to have to go through the probate process. And so if you own real estate, even if you have less than $40,000 included in equity and bank accounts and all of those things, then there might be a financial reason still to write a trust for that person so that their property can transfer outside of the probate process. There is a simpler solution to probate if you don't own any real estate and if all of your assets together total less than $75,000. And that process is called an affidavit for collection of personal property. And it's a really simple procedure in order to collect that personal property after you're gone. But generally, if you have less than $40,000, there are other reasons to do estate planning, things like getting incapacity planning documents in place, possibly changing who's going to receive your assets by drafting something like a will. But writing a living trust would not be top of the list for somebody who has less than $40,000. I have someone else asking, is a trustee a person? And yes, a trustee is generally a person, but it doesn't have to be. There are also things called corporate trustees, and there are people who aren't necessarily related to you or friends with you who are called professional trust or professional fiduciaries, and they can serve as trustees as well. So a corporate trustee would be like a bank, like US Bank might have a trust department. In fact, I know they have a trust department that would take on administering trust for people, but the kick side is that they charge 1% to 2% of the total trust assets every year. And so they kind of deplete the assets that are in the trust as they're administering them. But a professional fiduciary generally charges an hourly rate, something like $100 to $300 to administer a trust. And then a friend or family member can often be asked to administer a trust either for free or for a very reasonable fee, something like $30 to $50 an hour. If you have a living will, I'm not understanding why it goes to probate. That's a fantastic question. And a lot of people aren't aware of this and aren't aware that this is true. But unfortunately, with a will has to be probated in order to be effective. So in a will, you do certain things. You nominate a personal representative, but here that's the key word is you nominate the personal representative. The personal representative has to be approved by the probate court in order to start acting, in order to step into your shoes and start acting in your stead. And the way that they are approved by the court to act on your behalf and to step into your shoes and to be able to talk to the bank and do different things, the way to do that is through the probate process. So I completely understand a lot of people think that having a will in place is enough to avoid probate. Unfortunately, it's just not true. A will has to be probated in order to be effective. and that's just a sad fact of life. I saw that somebody had their hand up before, and I don't know if that person wants to be permitted to talk. If you do, go ahead and raise your hand again, and I will permit you to talk if you choose to unmute yourself. Otherwise, otherwise, maybe that was just a mistake that you had your hand up there for a little bit. All right. Will your assets be lost to the state? So does anyone have any idea how much money is in our state? And by our state, I mean the state of Minnesota, in the state of Minnesota's Department of Unclaimed Property. And the answer to that is over $700 million is in the Minnesota Department of Unclaimed Property. And across the states, that number is something like $58 billion that has ended up with the state departments of unclaimed property. And a big way that that money gets to those departments of unclaimed property is that someone dies or becomes incapacitated, and their heirs or their fiduciaries, the people who are supposed to be collecting their assets, just aren't aware of where all of the assets are. This is really common nowadays with electronic statements for banks. We used to be able to go through a person's mail and find where they kept their accounts at. But nowadays, it's very difficult. If you have electronic statements that are coming just to your email and nobody has access to your email after you're gone, it can be very difficult to trace where your assets are. And that asset ends up becoming lost and doesn't go to the people that you want it to go to. A lot of people don't think that this is a part of estate planning. I would say a lot of estate planners don't think that this is something that they need to address, but I completely disagree. As somebody who is building the wealth that I want to give to my kids when I'm gone, I can tell you I want them to have every dime that I'm building for them right now. And the way to do that is by creating an inventory of all of the assets that you have so that nothing is lost to the State Department of Unclaimed Property after you're gone. I see I have another question here. If you have a will, does it speed up the probate process? The answer to that is really, it depends. It can speed up the probate process, absolutely. And it does that by nominating the personal representative, which gives that person priority over anybody else who would seek to be appointed as personal representative. It also can clarify some things like who's going to receive your assets so that that doesn't have to be decided by the court using the intestate succession provisions. So there are some things that it definitely simplifies. Having a will, I wouldn't recommend not having a will in place. If you have nothing and you tell me, I can either have nothing or I can have a will, what should I do? Have a will, absolutely, no question. A will is going to be better. At the same time, if that will does things like cut somebody out, or if that will is drafted under suspicious circumstances, like for example, the personal care attendant drafted the will so that Uncle Ed could sign it on his deathbed. That's a suspicious circumstance, and that's not going to be an easy probate because there are going to be some serious questions asked about that will and why that will was drafted at the last hour by somebody who's not even a relative or a friend or anything like that. So generally, yes, a will speed up the probate case, but not always. Are assets from a small business handled differently, S Corp or LLC? That's a fantastic question. I don't think that I addressed this when I was talking about funding your trust, but it's very vital that those assets also be funded into the trust. And so for an LLC, it's a membership interest. And this is really important for a married couple, for example. Oftentimes with married couples, one person will own that LLC interest, right? Or that membership interest in the LLC. Or both of them will own 50% of the membership interests. Well, that doesn't have a joint designation on it. So we know that it should go probably to the spouse, right? But that's a question for the probate court after they pass away. And so it's really important if you own an LLC or if you own an S Corp, that you make sure that that gets into the trust so that you can have it go directly to your partner without having to go through the probate process. And that's just a really fantastic question. Thank you for asking that. so I could address it. So if I die and there's no will in place, will my wife have to go into probate for ownership of our home? And can other relatives claim ownership? Wow, fantastic question. In this case, for home ownership, most spouses will take ownership of the home in joint tenancy, okay? And because most spouses will take ownership in joint tenancy, there is, by operation of law, when the first spouse passes away, the other joint tenant inherits the entire property or receives the entire property. It's a confusing, kind of confusing thing, but when you're a joint tenant, you are a 100% owner of the property. It's just when that other person passes away that your 100% ownership of the property is realized, if that makes sense. Anyway, so home ownership, there's good news there that oftentimes with a home, that's going to go to your spouse immediately. However, if it was a property that you bought before you were married, and if there are some extenuating circumstances, things like you have children from a different person that you met before your spouse, or your spouse has children from a different person, then there can be some complications, including where the surviving spouse may just receive a life estate in the property and not the entirety of the property itself. But there are all kinds of rules to get into there about spousal elections and augmented estates and all kinds of things. It's very detailed and very specific to your situation. And so if that's an issue, I hope that you'll reach out to me, or a concern that you have, I hope that you reach out to me and we can talk about it in your specific instance. What if it's shared by brothers, but only in one name? And so my understanding of that question is, what if if there's a property like a real estate, maybe it's a cabin, but it's only in one brother's name? And I'll tell you, that's a big problem, because if the brother whose name is on the property passes away, that asset is going to somebody else. It's not going to the other brother unless there's an estate plan in place that specifically says, I want this to go to my other brother. But if the brother who has the property in their name passes away and they have kids, for example, those kids are going to receive that property. That's what the state of Minnesota thinks that you want. Or if they have a spouse, the spouse might receive the property. So that is a sticky situation. And I would encourage anybody in that situation to make sure to get some estate planning done, or to have that addressed so that the ownership is either joint, or there's another document that might work in this case called a transfer on death deed. And that transfer on death deed can say, if brother one passes away, then brother two gets the interest in the house. And so if brother two passes away before brother one, well, the gift fails and it ends up going to brother one's kids. But if brother one passes away first, then the transfer on death deed does succeed, or it does work, and it would therefore go to brother two. And I hope I didn't confuse everybody. I confused myself a little bit with brothers one and two, but hopefully that's pretty clear. Great questions, everybody. Keep them coming. I love it. Okay, this is really cool. With a trust, with a revocable trust or a living trust, you can make that living trust a real treasure chest for the people that you want to be beneficiaries on it. This is really cool. You can put something called asset protection over the inheritance that you are giving to that person. And I'm going to use the example of kids here because that's often the case. You can put asset protection over the inheritance for the kids. And in fact, it looks like I think almost everybody who answered has kids here. So you can put asset protection over the kids' inheritance so that if they're divorced or if they go through bankruptcy, their inheritance won't be touched. If they go through divorce, the divorcing spouse won't be able to access that inheritance that they received if it's in a lifetime asset protection trust. And the same with if they're in, for example, if they're in a car accident and they're underinsured and they are sued by the other driver or the family of the other driver, and they don't have any money to pay for it, well, that money is not accessible in that lawsuit because it's in what's called a lifetime asset protection trust and has that airtight asset protection over it. It is very cool. but you have to work with an attorney in order to get that asset protection over the inheritance to your kids. It's not something I've ever seen in a do-it-yourself, and it could go very wrong if somebody put it in a do-it-yourself type of situation. So this is something that I know is very real for people right now in the midst of COVID-19, and that is planning for incapacity. And or in, I guess in the wake of COVID-19, we've kind of moved past, hopefully we're moving past it at this point. Anyway, you might recognize the person on the screen. This person is Terri Schiavo, and Terri had a cardiac event where she ended up in a vegetative state and was being sustained on artificial nutrition and artificial hydration. And there was a disagreement between her parents and her husband about whether Terri would want to stay on that artificial nutrition and artificial hydration. Her parents thought that as long as Terri had a chance to be interacting with the world, had a chance of a miracle recovery, that she would want to be kept on that artificial nutrition. And her husband thought she wouldn't want to be kept in this state. The nutrition should be ended so that she can pass, so that she can die. And there was a huge court case. That court case went all the way up to the Supreme Court, and the conflict and court actions really rippled out across the United States. We were all watching what was happening with Terri Schiavo back in the mid-2000s. But I can tell you, it doesn't have to be this way. You can put in place a healthcare directive that says exactly who you would want making healthcare decisions on your behalf. And what's more, you can include in that healthcare directive the types of decisions that you want that person to make and how you want that person to decide things for you. And that is just so crucial to do in a situation right now. So I have here, what about someone healing from PTSD and is dealing with state help right now and inherit? Will that protection work for that, the bankruptcy protection thing that you discussed? Fantastic question. My recommendation is if somebody is healing from PTSD, and if they are, and let me just extend that out to a whole bunch of other lifestyle disabilities. If they are receiving government help because they can't live on their own, if they're receiving government help because they can't buy food on their own, if they are struggling with substance abuse, if they are struggling because they're going through a bad divorce, if they're struggling because they have an issue with gambling. In all of those cases, I would very much recommend that you have some kind of trust in place to hold the assets for that person so that they can have someone overseeing and protecting the assets for them. But absolutely, in the case that somebody is struggling with PTSD and is dealing with the state right now, if they were to inherit, directly, all of that money might be gone very quickly, paying for things that the state might otherwise be able to help with. However, if you have asset protection, if you have a trust for them, and if you put asset protection over that trust, then yes, it would be protected from things like bankruptcy and things like divorce. You could absolutely protect that inheritance for that person so that they're able to enjoy it instead of having it go to the state. Great question. Okay, so we've talked about a lot of things today. We've talked about guardianship for minor kids. We've talked about short-term guardianship and long-term guardianship. We've talked about probate and the probate process. And we've talked about how much time it takes to get through the probate process, as well as the astronomical cost that's paid by your estate to go through the process. We also talked about the fact that it's a public process. We talked about unclaimed property and how much money is unclaimed property. In the Minnesota Department of Unclaimed Property. We talked about estate taxes, and I was able to give everybody some good news when we talked about estate taxes. We also talked about incapacity and planning for incapacity. So you're probably asking yourself at this point, what can you do today to do the right thing for your family? And what should it cost to plan right? And I really want to talk about this. I really want to address what should you expect to pay in order to get a great estate plan in place. So the options when you plan, really, if you know that something needs to be done and you want to get something in place, your plan is your options are either to do it yourself or to work with a lawyer. And do keep in mind, not all lawyers are the same. So how do you choose? Would you benefit from working with an attorney? And I would like to provide some guidance on that question. I'd say if you own more than just your personal belongings, things like cars and clothing, jewelry and furnishings, if you own more than $75,000, or if you own real estate, then you would definitely benefit from working with an attorney to get an estate plan in place. And if you want to ensure that the people that you love stay out of court and out of conflict after you're gone, and you want to make sure that they have someone to turn to when something happens to you, then you really should work with an attorney. And if you want the kids protection plan, which includes the short-term guardianship, long-term guardianship, medical powers of attorney, and much more to ensure that your kids are well cared for after you're gone, or you want to avoid probate or estate taxes, or protect your children's inheritance with a lifetime asset protection trust, then you have to work with an attorney. Those are all things that you really have to work with an attorney to do. And if you want to guarantee that your plan is going to work for you when your family needs it, then you have to work with an attorney. And I always share this story. It's a do-it-yourself project because at heart, I'm really somebody who likes to try and get things done myself. And this story is about, it may have even been a couple of years ago now, but I had gotten 2 new fishing rods and reels, and I was going to take my son out fishing. But the rods and reels, they had shipped without fishing line on them. No problem. I got some fishing line and I wound the fishing line around the reel. I thought that I had everything going right. And as soon as I went to snip the extra fishing line, something happened and the fishing line just started jumping off of the reel, and there was a tangled mess of fishing line on the table that I was working on. That was not my proudest moment, but I share it here with you so that I can talk about do-it-yourself projects and when it's a good idea to do it yourself. I was able to get the fishing line and the fishing rods and reels cleaned up, and we were still able to go fishing that day without a problem. So there was very little risk, or there was very little damage that was done. I think that we lost 30 cents worth of fishing line or something like that. It wasn't a big deal. I also knew immediately that I had failed in putting the fishing line on the rod and reel. I saw it immediately. I knew that there was a problem right away, and I was able to address it. Didn't cost me a lot. I was able to fix the problem. Doing it yourself with an estate plan just isn't that way. Number one, you're not going to know whether it succeeded or failed. You're going to be gone by the time that your estate plan is being tested. And that is an unnerving feeling to have things that you're not sure if it's going to work or not. Number two, it's very expensive. If you write an estate plan that doesn't work the way that you want it to, that doesn't avoid probate or doesn't solve your estate tax issue, that's a very expensive problem for the people that you love to end up cleaning up. And it takes a lot of time. Oftentimes, trying to do it yourself means that it's not actually going to get done. And I've talked to so many people, I've helped so many people to walk them through the process after they have had a do-it-yourself plan sitting on their desk for 10 years. They have a Susie Orman trust package, or they have some sort of online do-it-your-will that they paid for, and they just haven't gotten around to it. And it's taken 10 years, and I'm able to get them through the process and get documents signed in 4 to 6 weeks. It's that simple. I can make it that simple for you and make sure that you're able to get it done. There's just an added little wrinkle. If you want to give your assets to someone other than your kids, then you really need to work with a lawyer in order to make sure that you get that exactly right. I see a couple of people saying here, reminder to offer to be hired for affidavit if you help with that, so that we can all rest easy with the secure way. Nice. Nice, okay. Talk about revocable versus irrevocable. I will get to that, I promise, in just a little bit. And I'm going to take a pause on the questions just for a minute as I talk about a few things here. So I want to bring us back to this quote. Again, this was not said about me, but this was said about another estate planning attorney. Someone has to graduate at the bottom of the class. And again, I don't think that this was said about that attorney's actual knowledge, but I think it was the model that the estate planning attorney was operating under. And I really want to highlight the fact that not all attorneys are alike. And you've probably gotten that feeling by listening to me tonight that I'm not like most attorneys. I'm not a very typical attorney, but I'm very passionate about what I do, and I love taking care of people. So someone has to graduate at the bottom of the class indicates that that attorney was probably practicing under a planning for death model or a typical estate planning experience. In a typical estate planning experience, you can expect form documents that are kind of set it and forget it. And you put it in the bottom of a drawer. The attorney probably didn't really explain it very well to you. And so you don't really understand what it means and what it says, or when you would need to contact the attorney in order to have another review of it. But you got it done, and you're just going to put it in the bottom of the drawer and hope for the best. And that's not a great result. That leads to the kind of court and conflict that can often happen, even when an estate is actually planned and designed. Typical experience doesn't keep money out of the Minnesota Department of Unclaimed Property. Something that I take care of, but most estate planning attorneys just don't address and don't think is part of the estate planning process. Typical experience may avoid probate, but may not. It's not always in the attorney's best interest to avoid probate, because for a lot of estate planning attorneys, they make money from taking care of the probate after the fact. And that if you have a will-based plan, if you own your home and you have a will-based plan proposed to you before they tell you about trusts and living trusts and revocable trusts, then there's a chance that that estate planning attorney relies on writing wills and then performing the probate after that person passes away. There's a chance that that's the case. Typical experience probably isn't going to keep your family out of conflict. It's just not, again, a focus of most estate planning attorneys. Typical experience is only going to focus on money, not your intangible assets, things like your stories and your values. The typical experience is going to leave assets to heirs unprotected. Not everybody is writing these asset protection trusts, even though they're so valuable and people want them when you tell them about it and you're able to give it to them. The typical experience is not going to have ongoing legal guidance, and the reason is that the typical estate planning attorney charges hourly fees and will continue to bill hourly after the fact, even if you just have simple questions about your estate and you just want some quick information about exactly what it was that you did. And the typical experience is not going to adequately protect the kids. A lot of attorneys will do the long-term guardianship, but not all will do the short-term guardianship or medical power of attorney or so many other things that are really necessary to make sure that your kids are raised by the people that you want and raised in the way that you want. You're going to be left with this question: will it work when you need it to work? And that's not a question you should ever have after having your estate plan done. Planning with me is totally different. I call it planning for life, and it is just a totally different experience. First off, I charge flat fees, and you get to choose the fee package that you want. So it's not a goodwill donation or anything like that, but I'll show you the different fee packages that I offer, and you can choose the package that fits for you. Planning with me keeps your money out of the hands of the state. We make sure to create an all-encompassing inventory so that the people that you love will find your assets after you're gone. Planning with me protects your kids totally in the immediate and in the long term. Planning with me is going to keep your family out of court and conflict. That's really at the heart of what I do. I'm a peacemaker. I hate to see families that devolve into conflict because they have to go through the probate court, where they have to try and decipher what mom and dad thought, said that they wanted in their documents. I hate to see that kind of thing. And I really want to help my clients to avoid court and to avoid conflict. Planning with me means that you're going to know that you made the right decisions, because I want to educate you and empower you to make those decisions. I'm not going to make them for you, but I'll guide you and help you to make those decisions and make sure that you have the information that you need to make them. Planning with me means that you can protect the family money from outsiders, things like a divorcing spouse or a bankruptcy. And planning with me means a lifetime of guidance and protection. And your plan is going to work when your family needs it to work, which is really what everybody's asking for. You want the value. You want it to work when it needs to work. And remember, it's really a gift that you're giving to the people that you love the most. So let's talk about cost. Let's talk about exactly what you should expect to pay for an estate plan. And just to review, I can tell you this plan will save your family at least $12,000 if all that you have is a house worth $400,000. And I realize for a lot of us, that's a very nice house, but that $12,000 is 3% of the $400,000 value of the house. And that's the fair market value. It's not even necessarily the equity that you have in the home, but you can expect to pay somewhere between $12,000 to $24,000 if the only asset that you have going through probate is that house. And if you have assets over $3 million, then this planning will save your family at least 13 cents on the dollar for every dollar in excess of $3 million. And that's planning for estate taxes. I know this doesn't apply to a lot of people, but if you have more than $3 million in your estate, it's vital that you get some estate planning done, because you can actually double the Minnesota estate tax exemption if you're married, but you have to do some planning in order to do it. And there are other ways that we can plan for your assets and make sure that we're able to address any estate tax demands on your estate for after you're gone. All right. A typical estate planning attorney is going to charge a minimum of $1,500. And I believe that this number has actually gone up. I believe it's above $2,000. It may even be above $3,000 for a typical death plan with a typical estate planning attorney. You can be almost guaranteed it's not going to keep your family out of court or out of conflict. It's not going to ensure your assets aren't lost to the State Department of Unclaimed Property. And it's only going to cover your money, not your kids' immediate care or your values, your insights, stories, or experience, things that I'm able to capture in something called a family wealth legacy interview that we do. Those are often your most valuable assets that you want to share, those intangible assets. The alternative, you can work with me. I'm a personal family lawyer, and you can learn specifically what your family needs and choose your own fee package, likely to range somewhere between $2,000 to $8,000. And you're going to know that your plan is going to work when your family needs it to work. And I'll tell you, most people that I plan with end up paying somewhere between $4,000 and $5,000. That's a typical revocable trust-based plan. That's the typical fee that most of my clients choose. But there are options to do planning at a lower level for that $2,000, even that $2,000 range. So let me make this really easy for you. I want to give you a free one-on-one meeting with me. It's a 2-hour-long meeting called a family wealth planning session, and I want to give that to you absolutely free just for attending today and committing to reserving your family wealth planning session and doing the pre-work ahead of time before we meet. If you actually do that, I really want to give you this family wealth planning session for absolutely free. The family wealth planning session is a virtual session. Again, it's 2 hours, and we're going to be talking about the things that we talked about today, but in specific for your situation. What does it look like for you? And what does it look like in your family situation and with your assets? And we can get very specific and very detailed into exactly what you can expect or what your family can expect after you're gone in that session. So that's the first hour, is really educating you about exactly where you're standing at right now. And if you choose to continue and to write an estate plan with me, then we can move into that in the second hour and actually design your estate plan together. And if that's the case, I want to give you $250 off the estate planning package of your choice. But in order to secure that $250 off, I need you to reserve your appointment before the end of the week. And I just put in the chat my calendar link so that you can access that and you can go and see my calendar. My guess is that I probably don't have anything. You want to click on the calendar and you want to click on family wealth planning session. My guess is that I probably don't have anything in, I don't have anything in July. I don't have anything in August anymore. So September is the earliest that you can sign up to work with me. And the reason for that is I only accept a certain number of clients every month. I have a very limited book of clients that I accept. And the reason for that is because I give my clients a lot of my time and attention. And you can tell, we have a very in-depth meeting together in order to determine exactly what you might need from an estate plan and exactly what how we can make that estate plan as affordable for you and take care of your family in the very best way possible. So I really encourage you to sign up. I really encourage you to secure that $250 towards the estate plan of your choice. The reason that I give you that $250, if you book your appointment before the end of the week, and I know the appointment isn't going to be before the end of the week, but if you put yourself on my calendar for September or October, whenever works for you, if you put yourself on my calendar before the end of the day, Saturday, I want to give you that $250. And here's the reason. If you get yourself on my calendar, I'm not going to have to follow up with you and figure out how to get you on my calendar. And that is a huge value to me. I also believe in rewarding people for doing good things. And you have done a very good thing by being here with me tonight and by spending more than an hour with me in order to learn about this topic and educate yourself and empower yourself to make decisions for your family that will get your affairs in order for your family. So I believe in rewarding that. I also want you to keep the momentum. And the best way to keep the momentum is by taking time either right now or in the email that's going to immediately follow and scheduling your time on my calendar so that we can have this conversation together and have this family wealth planning session together. So that's why I want to give you the $250. And really, it's a gift that I want you to accept. It's a gift that I really want you to have here. So I do see some questions coming in, and I will answer those right now. But first, I just want to say your next steps. Schedule your free family wealth planning session. You should be able to find my link in the chat box, or you should be able to type it in from what's up here or scan the QR code in order to access it. But I really want you to schedule that family wealth planning session with me so that we can talk about the specifics of your family and the specifics of your assets. And I want you to use that $250 towards the plan of your choice. So I have here a question, can I talk about revocable versus irrevocable trust? And absolutely, I can talk about that. A revocable trust is a trust that you can revoke or amend at any time. And so for a revocable trust, generally you are the settlor, you're also the trustee, and you're the beneficiary, the person who can benefit from that trust. Because you're serving in all of those roles, the grantor or settlor, the trustee, you get to also retain for yourself this ability to make changes to the trust in the future if you choose to. So that's what a revocable trust is. It's literally, you can revoke it, you can take it and tear it if you want to and say, I don't want to have a trust anymore, I just decided. Or you can amend it and change provisions in that trust, and that's not a problem. As long as you are still acting as settlor, you can make those changes. An irrevocable trust is one that you cannot revoke, that you cannot amend anymore. And there are some special rules where you can possibly amend some things and possibly do something called decanting it into another trust in order to make some amendments if you choose to. But really, that's what you need to know, is that with an irrevocable trust, you can't revoke it anymore. And oftentimes that's because you as the settlor are giving your property to someone else. This isn't you anymore acting as trustee. It's somebody who's not you, but it's going to oversee your assets and administer them for beneficiaries as well who aren't you during your lifetime. So that might look like planning for medical assistance and planning for a stay in a nursing home. But oftentimes an irrevocable trust is written for that purpose, where a settlor puts some property into a trust that they're not administering or that they're not a trustee of, and that is to benefit the kids and not to benefit themselves. And they do that in order to get the assets out of their name and to gift it to somebody else or to something else. And if they're able to go for 5 years before requesting any medical assistance or requesting any help paying for nursing home care, that asset that they gave to that trustee in the irrevocable trust is no longer accessible for a state recovery or a part of their assets when the medical assistance calculation is done and the application is made. There are other irrevocable trusts. There are irrevocable life insurance trusts where, again, the beneficiary is someone other than yourself. There are all kinds of irrevocable trusts out there. Also, revocable trusts become irrevocable trusts after the settlers die. After the settlers are gone, that trust is written in stone then. It can no longer be revoked. It can no longer be amended. The trustee just has to follow the rules as they were written by the settler when it was originally done. Okay, so that's the difference between revocable and irrevocable trust. Is $2,000 my lowest rate fee? And the answer to that is basically yes. We can talk about if there is some tertiary type of estate planning that you want done, or some other items that you want to address, but you don't want to write an entire estate plan. We can talk about other ways to do it. But generally, a $2,000 estate plan would be a will-based plan where we would take care of incapacity planning, and we would take care to make sure that the people that you want to receive are going to receive your assets. But yes, $2,000 is on the lowest end of my rate or fee table. Yes. Okay. So I hope that you have had a chance to go ahead and pull up my calendar and see what it looks like. And I hope that you've had, a chance to find a time that works for you. Again, you're probably looking at times in September or October. And I hope that you'll look there and find a time that's going to work. I can tell you, it looks like some spots are starting to drop off. So I'm happy to see that people are booking appointments. I really want to have the opportunity to meet with you and to help you to understand exactly what's going to happen after you're gone, or if you become incapacitated. Again, the family wealth planning session can be done totally virtually. We can do it over Zoom, just like this. And it's from the comfort of your own home. And we can talk about everything. We can talk about who would be the person to collect everything for you. Who would be the person who would take responsibility and want to step into your shoes, make sure that they had all of your bank accounts accounted for, all of your investment accounts accounted for, all of your property in the right place. Who would be that person for you? And we'll talk about what would happen if you became incapacitated. Would there need to be a court case? If you don't have an estate plan in place, that's often what needs to happen, is that there needs to be what's called a guardianship or a conservatorship case that needs to happen, so that somebody can be appointed to deal with your health decisions and to deal with where you're living, or to deal with your finances if somebody needs to be able to deal with your finances. And we can talk about what would probate look like for you based on your assets and based on your family and your family dynamics. What would the probate case actually look like, and what would it cost? How much time would it take? Is it likely that there would be some conflict in that probate case, or does it seem like it would be a conflict-free type of situation? And we'll talk about estate taxes for you, and we'll talk about whether you're likely to owe any estate taxes and how we can plan for that. We'll talk about how do you want the people that you love to receive your assets? Is it all outright at a specific age? Is it outright at different ages? Is it that you want them to have the asset protection that we talked about and that is so valuable? I'm looking here to see if there are any additional questions, and I hope that if anybody has a question that I haven't answered, or if somebody would like me to speak more on a particular topic, I hope that they will put that into the chat right now, because I'd love to see if people have additional questions, and I'd love to be able to address them before we get off of the line here. And I am not seeing anything right now. And that's just fine. And that is just fine. Maybe I've answered all of your questions. I hope that I have. So look for my email. I'm going to email out the recording of this presentation, and I'm going to email out a link where you can see my calendar and where you can book. And I understand maybe you can't book the appointment right now because you need to coordinate with a spouse, or you need to coordinate with childcare, whatever the case is. I completely understand, but I really encourage you to get it booked before the end of the day Saturday. I encourage you to keep the momentum going on this. You're here and you're ready to take the next step forward. You care about your family and you care about the people that you love. I know that you do, and I know that's motivated you to be here and to get this rolling. And I encourage you to take the next step, which is to get on my calendar and secure your spot so that you can get this addressed, even if it's not until September. At least you can get the ball rolling and get this addressed and get this taken care of. Thank you, everybody, for joining me tonight. Again, my name is TJ Scott. I'm an estate planning attorney with the law office of Timothy J. Scott. Look for emails from me, and it's been great talking with you all tonight. Have a great night.